Tonight we have invited Attorney Malaguti, who is our Assistant Town Solicitor, to talk with the Budget Committee as well as our residents about RSA 91A, which is the right to know law. So without further ado, welcome and thank you so much.
Thank you, Mr. Chairman. Thank you, members of the committee, for having me here tonight. I was asked to speak a little bit about the right to know law, RSA 91A. This is a state statute that is continually updated by our legislature pretty much every year. This is an area where the legislature does make a number of different changes. There's a number of court cases that take place every year, so it really is an area to keep our eye on. I was asked to give this presentation as a refresher, but with the collective experience of this committee, I am certain that these are not new topics for anyone. And I expect that this committee's compliance with the right to know law is probably quite high. But it is a good practice for all of us, I think, to periodically talk about these issues because they do change and they do come into new areas and applications. Our Constitution actually references the right of the public to know. All power residing originally in and being derived from the people, all magistrates and officers of government are their substitutes and agents, and at all times accountable to them. Government, therefore, should be open, accessible, transparent, and responsive. To that end, the public's right of access to governmental proceedings and records shall not be unreasonably withheld. RSA 91A has similar language. Openness in the conduct of public business is essential to a democratic society.
Can I interrupt you real quick? Do you mind just turning the microphone to you, please? So, thank you.
Better?
Yes.
Openness in the conduct of the public business is essential to a democratic society. The purpose of this law is to ensure both the greatest public access to the actions, discussions, and records of all public bodies and their accountability to the people. So because the purpose of this statute is so clear, and because it's not just a law but a constitutional requirement, exceptions to these rules are narrowly construed, and the statute is construed in favor of access and disclosure. What does this mean? It means that, in practical terms, the burden would be on us, the town or the government, to justify not releasing a document, to justify closing a meeting, to justify something like that. If there is a doubt about whether something should be disclosed or whether a meeting should be closed, it is disclosed, and the meeting is not closed. The right to know law is not the same thing as the Freedom of Information Act. You may hear those two terms used together quite a bit. The Freedom of Information Act is a federal statute that does not strictly apply in New Hampshire. However, it is very similar, although not identical, to our law. Our Supreme Court has stated that the Freedom of Information Act should be consulted when there are issues of interpretation arising under our right to know law. Sometimes we get requests, written requests for under the Freedom of Information Act. We might get a public records request. We might get a sunshine law request. These are the terms that other states sometimes use for their right to know laws. In general, it's our practice not to find technical reasons to deny right to know requests. And so if we got a request made under the sunshine law, for instance, we would just treat that as a right to know request and respond accordingly. We think this is consistent with the spirit and the purpose of the right to know law. There are two major components to this law, the first being public meetings and how that is handled, the second being governmental records and access to those. I'll start with the meeting requirement and the meeting concept. The law generally requires that the public's business take place out in the open at duly noticed and convened public meetings. What is a meeting? A meeting is defined as the convening of a quorum of the membership of a public body, whether in person, by means of telephone or electronic communication, or in any other manner so that all participating members are able to communicate contemporaneously for the purpose of discussing, acting upon a matter or matters over which that body has supervision, control, jurisdiction, or advisory power. Let's just get it out of the way. The Budget Committee is clearly a public body. The right to know law applies to the Budget Committee just like it applies to any other committee of the town of Londonderry. So why is the definition of meeting so important? Because with limited exceptions, it's a right to know law violation for deliberation or discussion among a quorum of a public body to take place outside of a meeting. The law does give some flexibility here, anticipating some of the problems that arise in practice. One of those problems is chance social or other encounters that are not convened for the purpose of discussing or acting upon a matter under the Budget Committee's, for instance, jurisdiction. So if members of the Budget Committee go to Old Home Day together, but they don't discuss or act upon anything under their jurisdiction or supervision, that's not a meeting. The interesting issues center around email and social media, and I'll address those as a separate topic in just a bit. However, I'll mention one example of a 91A violation here. Let's imagine that a member of the Budget Committee is interested in knowing where his or her colleagues stand on a particular issue. Understanding the definition of meeting that I just gave you, he calls one after the other separately. So technically, this is not a meeting because a quorum of the body is not convened at the same time, and they're not able to contemporaneously speak to each other. But it still violates the right to know law in two separate ways. This is likely a deliberation or a discussion outside of a meeting, and it also violates the spirit and the purpose of the right to know law, which is a separate violation. I'll next move on to governmental records and accessing those records. Again, definitions are important, and I don't like to read statutory text when I give a presentation, but we really need to understand what the definition of a governmental record is. Any information created, accepted, or obtained by, or on behalf of a public body or a quorum or majority thereof, or any public agency in furtherance of its official function. Without limiting the foregoing, the term governmental records includes written communications or other information, whether in paper, electronic, or other physical form, received by a quorum or a majority of the public body in furtherance of its official function. Doesn't have to be at a meeting. It can be information records that are received outside of a meeting as well. Governmental records, to be governmental records, must exist somewhere in physical form. And that doesn't mean that they have to be on paper. What it means is what's in your head is not a governmental record. And for this reason, you can't file a right to know request demanding that a governmental official answer questions or create records to answer your question or to answer your request. There are other perfectly good reasons why governmental officials should answer questions, but the right to know law is not a source of authority requiring it. An example of a record that is not a governmental record would be an email between a member of the Budget Committee and a member of the public. However, if the member were to forward that email correspondence with a member of the public to a quorum of the committee, it's now a public record. Conversely, if a Budget Committee member acting as a liaison to the police department, for instance, exchanges an email with the police chief about the police budget, that's likely a governmental record because even though there isn't a quorum party to that communication, the liaison is acting on behalf of the Budget Committee as a whole. If I send myself a recipe that I found on the internet and I send it to my Londonderry email address, that's not a governmental record unless the request is framed around use or misuse of my official email address. Really what we're looking at under the right to know law is does the record tell us something about what the government is up to? And me sending myself a recipe, absent those circumstances that I just referenced, does not create a governmental record. We receive right to know requests almost every day at Town Hall and at the various departments, and responding to them occupies a lot of my time. I know that the finance director, the town clerk, and the assistant town manager are heavily involved in this area as well. You may find it interesting to know what the primary areas of focus are for most right to know requests. Elections and voting. I think this is what I would say is the number one issue. Sometimes requests come in from the media, sometimes from citizens, very often from interest groups and political parties. Police records generate a lot of attention. These are usually requested by the media in high profile or other noteworthy cases. For some reason, there seem to be a lot of companies that are interested in gathering and compiling records of our financial transactions, outstanding checks, payments that we've made to third parties. This is all information that is disclosable in general under the right to know law, even if it's for a commercial purpose. We often get requests asking us if we have a policy on something and what the policy requires us to do internally. We get requests around pending or contemplated litigation. So if somebody is thinking about suing the town, they can request information in their building file or their zoning file, for instance. Topics of local controversy. I'm sure everybody has one or two of these in their mind. People can come in and ask us to give us everything that we have on a particular expenditure. And in general, we're required to do that. And then lastly, losing bidders on town RFPs. Very often the losing bidder is interested in seeing the winning bidder's information. And so unless there's something confidential or proprietary that they shared with us in confidence and with an assurance of confidentiality, we would release that information. I want to close by addressing the right to know law in two practical settings, which you asked me to do: email and social media. The same principles just discussed apply to both of these mediums. Email is a great tool for non-substantive communication. For example, it can be used to gauge your availability for meetings, non-meetings, et cetera. It can be used to disseminate meeting materials, minutes, and to communicate with constituents. Town staff can and frequently do, in my experience, use it to forward materials to committees and officials. And it can be used for liaison communications. It can also be used for the giving of legal advice. It cannot be used for discussion or deliberation, and that's really where most of the violations that take place occur. Based on the requirement that there be a contemporaneous communication where everybody can participate at the same time, hear and see each other, I take a different view than some do who say that the use of email risks convening an inadvertent meeting. I don't think that's the issue. I think the greater risk is that email communication can be used to circumvent the purpose and spirit of the right to know law, and it can be used to discuss and deliberate outside of a meeting, both of which, as I stated earlier, are right to know law violations. The right to know law does specifically state that sequential communications, that is emails, shall not be used for that purpose, for discussing or deliberating. For this reason, and to prevent the beginning of a thread which would invite discussion or deliberation, it's really a best practice adopted by many boards and committees and by folks at Town Hall to, if you need to send an email to a quorum of the committee, it's best to enter everybody's email address as in the BCC line, because that will prevent somebody from hitting reply all, as we've all done, and starting a conversation that could get everybody in trouble. Emails involving town business should take place through your town email address. This is because governmental records can be created on personal email servers. It's best to keep everything town-related in one place so that if there is a right to know request or a subpoena, the information is easily accessible and personal content isn't intermingled. Lastly, because of retention requirements that apply to governmental records, I advise that emails on town servers should never be permanently deleted. To keep a clutter-free inbox, either create folders for unneeded emails or move emails to the trash folder, but don't empty the trash folder. Lastly, a few words about social media. The Budget Committee and its members have the same right to use social media that everybody else has. But we need to be cautious to avoid creating problems both for yourselves and for the town. And when I say creating problems for yourselves, the right to know law has penalties that actually could be assessed against officials in their personal capacity if they act in bad faith to violate the right to know law. So it's a pretty high bar, but certainly if somebody is doing something in violation of this statute and they really should know or they do know that it's wrong, they can be fined by a court if that occurs. So I suggest that the best practice when speaking on social media on a matter within the purview of the Budget Committee is for members to make it clear that they are not speaking for the committee unless they actually are speaking for the committee, in which case the communication would be a governmental record. However, I advise against speaking for the Budget Committee or any other body on social media or otherwise using your personal social media account as an extension of your position. Doing so may create First Amendment issues for you and for the town. What I mean by that is that several courts have found that personal social media platforms used for official purposes become public forums, and the First Amendment then applies. That can become a problem because if the First Amendment applies to a public forum, there are limits on the ability to moderate the discussion, to block users, to regulate the content. Let me be clear. Every member has the same right that Joe Citizen has to express his or her views on social media. This includes matters of local concern, and it includes budgetary matters, even for that matter. Just don't be a Budget Committee member on your personal social media page, and don't conduct Budget Committee business or make Budget Committee announcements on social media. There is an exception, I believe, for political campaigning. This is an important platform and an effective tool for campaigning. Just make sure that if you are speaking as a candidate, that you indicate that you're speaking as a candidate. I believe the better practice would be to create a separate identity for your political campaign. One hard and fast rule in this area would be to avoid debating and discussing issues on social media with other committee members in such a way as to circumvent the spirit or purpose of the right to know law. This is the same issue that I just referenced with the email communications. However, it would certainly be a bad look, even if it's technically not a meeting, for the reasons I discussed earlier, if a quorum of the body is on the same social media page debating an issue. This can be, as an aside, particularly problematic for quasi-judicial bodies like the ZBA, who really are not supposed to prejudge issues and should not be expressing prejudgments outside of their deliberations in a meeting. To my understanding, the Budget Committee does not have an official social media presence. Again, that's not to say that you should not, as a body, have an official social media presence. But if you do, I think that there is legwork that needs to be done in terms of policies and making sure that you understand the host of First Amendment issues that might apply. A few more suggestions as I bring this presentation to a close. RSA 42(1)(a) makes it a violation of an official's oath of office to disclose confidential information and subjects the member to removal. So this would include, under that statute, information that was sealed in a non-public meeting of the governmental body. So if there was a non-public session and after the body came out of non-public, they voted to seal the minutes, and then something that was discussed appeared on social media or was disclosed in any other way, that is a violation of that statute. That is big trouble. Lastly, unless carefully scripted and for a specific reason, no member should ever disclose legal advice the board has received from an attorney. And the reason for this is that public disclosure of legal advice could arguably waive the attorney-client privilege that applies to that information, not just with respect to the matter that was disclosed, but also potentially with respect to unrelated matters. That's a bad outcome, and that's something that is not in any board's interest. I was asked to briefly address how to make a 91A request. So the easiest way, it depends on what the record is that you're seeking. So if you are looking for a record that's immediately available within regular business hours, we're required to make that record immediately available, and you can inspect it at the town hall, at the department, wherever. That's not to say that most records are immediately available. Sometimes the request will not be phrased in such a precise way that we really know, without talking to the lawyer or what have you, what's being sought and if there might be exceptions. But if somebody came in and asked to look at something very basic, something that's handled by the clerk's office on a daily basis, they would be able to do that in all likelihood. A request probably should be in writing. We prefer that they be in writing so that if there's ever a question about whether we responded appropriately, there would be a record of what the request was. That being said, if there's some reason a written request can't be made, or if somebody just refuses to make a written request, we are going to go ahead and try to honor that and treat that as a right to know request in favor of disclosure and transparency. You may see the answer accompanied by my characterization of what the request was to create a record, but we try not to stand on formality when it comes to answering the public's questions and giving them information. I hope this has been helpful. I'm happy to take any of the committee's questions, and thank you for having me here.
Thank you. Do I have any questions, comments from the committee?
I do. So if I were to make a post online saying, hey, come to the budget committee meeting tonight, and put a link to the town website with the agenda, would that be myself acting on business as the budget committee, as a member of the budget committee?
So I think I'm going to give you the lawyer's answer, which is it depends. I think that a court, in looking at this issue, would look at the totality of the circumstances and really how your page is being used. Are you using it? Are you using government resources, for example, to fund this page, to manage this page, et cetera? Because that's kind of the extreme. I mean, political people on the national, the state political level pay people to manage their social media presence. That's not this. So I don't want to give specific advice on that issue. I would say it's best not to do that. I think that certainly it's great for as many people as possible to know when the meetings are. If you're going to do that, I think that you can. There are other ways to do it, but now that being said, if that's the only thing that's taking place on your page in terms of reference to the fact that you're on the budget, it doesn't really even reference that you're on the budget committee, it just references that there's a budget committee meeting, I'm not overly concerned about that. But a court would look at other factors to include how you've labeled your page. Does it say budget committee member? Is it kind of open as a forum for input on matters under the budget committee jurisdiction? The more you start to put those things together, the more it looks like a public forum. Now, it's not a violation to have a social media page that's a public forum. Just understand that it limits your ability to do certain things that most of us would want to be able to do with our social media page. Blocking people, specifying what can be discussed and when, things like that. So it's not an absolute. I think it's best to kind of avoid mixing business and pleasure, but I think to answer your question, I don't think just blasting out the link is likely going to be enough to support a violation or just to find a public forum.
I think a good thing is the town has a Facebook page, and if you would like the town to post it, you direct it through me, and I'll reach out to Kirby, see if she can post it, and then if you were to share the Londonderry's original post on your personal page, that might be that would be a little different, I would think.
I think that's right, and I will say I think that there are several other kind of local social media groups, some of which I follow, that do a very good job, I think, of getting this information out there as well. So I do think it's important to get it out to as many people as possible. I think that's a good idea for one way to mitigate that risk.
Right.
You mentioned about email. Don't delete it, save it. Just put it in the trash, but don't delete the trash, right? Or the junk mail. What about texting?
Yeah, so texting can be a governmental record. Certainly, I have a work phone and I have a personal phone, and I try to keep my work communications on my work phone. If you don't have a work phone or a Londonderry phone, and you're using your personal phone to discuss a matter, understand that, look, you need to go back to the definition of governmental record. So if you are texting with somebody in furtherance of your role as a liaison to the budget committee, probably a governmental record. If you are having a conversation with your spouse about a matter, a budgetary matter, not a governmental record. But you do need to be mindful of the fact that if there's litigation, if there's a right to know request, we are going to be asking whether there's relevant information on your cell phone or on other devices.
Thanks.
So, to pivot from that, or on that, if I do a group text with everybody in the budget committee, that's a quorum. If I do group text with a simple majority, or is that the correct term? There's 7,
Yep.
with 4 of us, that's a quorum.
That's a quorum. Yep.
So, sending Steve a text, hey, are you gonna be here tonight,
Yeah.
is not necessarily, or is it?
Sending Steve a text saying, are you going to be here tonight, is not a 91A violation, because you're not discussing or deliberating upon a matter under the Budget Committee supervision. Technically, for the reasons I discussed, reference email, if you were to make the same communication to a quorum of the Budget Committee, not a 91A violation in all likelihood, because again, it's a non-substantive communication. Yes, it's a quorum, but it is not discussing or deliberating a matter that you have supervision over.
And just one thing, just for the committee, just my policy is, any mass communication, as Attorney Malaguti said, 1 will be channeled through the chair, and 2, I will, as we have been, I will send it to myself, BCC everyone else, so that no one makes that mistake of the reply all. It's a great way to prevent an accident, because regardless, even if it's an accident, it's still, a violation. And,
Correct.
And, it's my goal to protect us as much as possible, and doing that way, we'll do that. What about, so you'd mentioned, real quick, what's the sunshine law?
So it's essentially the same thing. I think certain states just refer to it as their sunshine law. It's the same thing as saying their right to know law.
Okay. And what is the duly noticed time frame?
So in general, it's going to be at least 24 hours in advance of the meeting. And it's either going to be run in a newspaper of general circulation or posted in 2 prominent places.
Okay, so in a newspaper or 2 prominent places?
Correct.
So like a Facebook and the town website?
So I wouldn't say the two prominent places should not be Facebook and the website. The 2 prominent places could be town hall and the town's website.
Gotcha.
Because the law specifically says that one of the prominent places can be the town's website.
Okay. And then, so you'd mentioned one member calling another one and then calling another one. Is that defined as polling?
I'm not sure.
Thank you. What was it again? Hub and spoke.
I'm not sure exactly the way, if you're using that as a term of art or.
Okay, let me rephrase that, sorry. If I call Steve, hey, Steve, what do you think about, the school's budget? I think it's crazy, we should, and then go to Jonathan, and then go to Jen, and whatever, is that a violation? As the chair?
It starts to feel like it could be violating the spirit and the purpose of the law.
Okay.
It's strange. It's kind of counterintuitive that all deliberations are taking place out in the open, but that really is what the law and the Constitution requires, I think. If and again, I don't want to give license to anyone, but if you were to have, bump into somebody who's on the committee at the grocery store and have a conversation with them, is that technically, first of all, it's not a meeting. You are discussing something within the supervision of the committee outside of a meeting. Are you doing it in a way that violates the spirit and the purpose of the right to know law? That's going to be a factual question, And as a lawyer, I don't like factual questions because that means you're already in court and you never know what's going to happen when you go to court.
Okay, thank you. Anyone else have anything they'd like to ask or add?
I got some questions, but I'll ask them later. I work in IT, so the old email thing between business and public, like government agencies, are slightly different. We stick with the email here strictly for budget stuff. We don't use it for personal email. Same thing at work, but at work, a lot of people mix them. But like we tell them, you use your work email, it's work property. You send a personal email across your work email, it's being archived and backed up. It is a company record. So believe me, if you use your email. So it's same here. If we look at it as if I use the Londonderry Town email, I figure it's a property of Londonderry Town to give to anybody they want that comes in and says they want it for the budget committee. But you made a comment earlier that if I was to email the dog catcher and say my dog got loose or whatever, it's not town business, so they don't have a right to know. And I'm thinking, if it's on the town email, they should be able to say, I want to see the copy of the budget committee's emails between this date and this date, and be able to see everybody's, regardless of what it is.
Yeah, so I agree that it's clearly town property. If there, and you shouldn't have an expectation of privacy, I agree, in anything that's taking place on your town, through your town email account. Is it a governmental record? I think, let's go back to the definition of governmental record. And I think it's going to depend on kind of how it's framed. If the question is, why are you having why is a town official using a town resource to have these conversations? Probably a governmental record. If it's just a one-off and it's personal in nature, can the IT director here see it? Yes, they can, because it's you don't have an expectation of privacy in it. It's
Right.
Town property. Is it a governmental record? I would come back to the words "in furtherance of its official function." You sending that email is not really in furtherance of your official function. Therefore, I don't know that it's a governmental record.
Because I was thinking that, like, the town could see all of our emails, but it doesn't necessarily mean that the town has to give it to a right-to-know person.
Correct.
In other words, you don't have to give all of our emails. They could go through and say, these are the
Exactly.
emails pertaining to your thing that we're going to give you.
Exactly right, and that's how it works in practice. Is
Right.
somebody, probably me, would be reviewing and making the determination: is this a governmental record? Is it responsive to the request? Sometimes the request, doesn't. It's not precise. It's a little hard to tell exactly what's being requested. Sometimes people aren't requesting what they think they're requesting, so it can be a little bit of a messy process.
All right,
Thank you.
thank you very much for your time.
Thank you for having me.
A great presentation and very well put together. So
I'm happy to
thank
come back anytime.
you. We might hold you to that.